Everybody, I'm Kuan Hon, and the point of this talk really is to try and raise awareness of some major issues that are going to affect you personally as developers and also your organizations. So they've asked me to rate this session, so here it is. Right, after an introduction, I'm going to be talking about mainly intellectual property. That's what I've been asked to talk about. I'm going to talk a bit about data protection as well, if there is time. I don't know whether there's going to be time for questions, but I'm around later on or tomorrow. So by way of introduction, this is me, 4 hats, 5 clouds, and 2 weasels. I have 2 hats in the sense that I've got degrees in both computing science and law, and I've got 2 other hats in that I am both an academic and a practitioner. So with my practitioner hat, I've worked on several cloud law projects, including being the lead author of 8 chapters of this cloud computing law book. And with my practitioner hat, I have advised clients who are both cloud providers and cloud customers on legal issues to do with cloud computing. So you're going to hear quite a lot about cloud computing. The 2 weasels are that first, this is just general information, not legal advice. And secondly, what I say represents my own opinions and not necessarily any organization with whom I'm associated. And here is the musical version of my disclaimer for Elvis fans, but only sing this in the shower, because if it's a public performance, you risk infringing copyright in the music, as we're talking about intellectual property rights. So, laws are simply rules that the state will back and the state will enforce. So, it can come from legislation, acts of parliament here, what judges say. And of course, the enforcement system will include courts, regulators, so you could be jailed, you could be fined, etc. And a contract is just an agreement between parties, who's going to do what happens if they don't, etc., that the state will enforce. And of course, because it's an agreement that the state will enforce, there are situations where the state will not enforce a contract. So certain contracts will be completely invalid because the state doesn't recognize them, or certain parts, certain terms of contracts may be invalid or unenforceable. For example, laws to protect consumers against unfair terms. So, intellectual property. Intellectual property is intangible property. Property you cannot, it's not physical property, it's property you cannot touch, and obviously it's state-backed. It's rights to control or monopolize the use of information. That's all it is. And of course, the most well-known will be things like copyright, as in source code, patents, inventions, which is possible for some kinds of software. I do want to say something about data ownership, because people always keep saying, you know, owning your data. Do you own your data? Who owns your data? That is a fallacy. Ownership, remember, like any other law, it's a state-backed concept. And that applies to physical property as well as intellectual property. If the state passes a law saying they're going to expropriate your house, then they will own your house and you won't. It's a state-backed concept, ownership. So really, with data, it's more about control. And yes, you can control data through intellectual property rights, like copyright, based on the limits of the law. But there are also other laws, like the laws on data protection, which enable control of data. But that's not the same thing as ownership. And of course, legal control is not the same as practical control. It often is overlaps, but it's not necessarily the same thing. So, with software, basically you create software, you might exploit it, and use it, or other people use your software. So, the key issues with intellectual property rights, what are those rights? How do you get them? Do you have to register or file to get a right? I mean, with copyright, in most cases, you don't actually get copyright until it's whatever it is recorded. When will the right expire? How can you transfer or license them? What are you allowed to do or not allowed to do? What are other people allowed to do or not allowed to do? What's restricted? What constitutes infringement, for example, of copyright? And what are the exceptions where even if you've got a right, like copyright, other people are allowed to do stuff anyway, like in the US, fair use, or in the UK, fair dealing, which is a lot narrower. And I emphasize that it depends a lot on which country's laws you're talking about. Different jurisdictions have different laws. Some of them might be broadly similar because of international treaties, but a lot of them, the detail is going to be different. And of course, the devil is in the detail. And with so many countries, it is just, and talking about digital data and the internet is actually pretty difficult to reconcile all these laws and to work out which ones apply and what's happening under which law. So the main thing, of course, I want to focus on is creating software. So you will, of course, have your source code. You might have other content, like in games. You might incorporate graphics, music, etc. If you create software, what is the ownership situation? With source code, it's usually copyright or patent inventions that apply. And different countries, as I mentioned, have different rules. So, for example, software patents are much easier to get in the US than here. Interestingly, last week there was a case in the US which actually seems to be reversing the trend and not allowing software patents in quite so many cases as before. It's kind of interesting because traditionally a lot of US courts have been very much in favor of software patents. So I just wanted to ask, who is an employee working for your organization? Okay, so most of you. Anybody who is a consultant or contractor? So a few of you. Okay, right. Well, so let me ask you this question. You write code, who owns the copyright? Who thinks you own the copyright? Who thinks whoever hired or engaged you owns the copyright? Okay, so most of you. And who thinks it depends? A few of you, okay? So most think it's whoever hired or engaged you. Okay, and supposing you work on a side project in your spare time. So who owns the copyright and the code? Who thinks it's you who owns the copyright? Okay, oh, not many people, okay. Who thinks this is your employer who owns the code? Nobody? Okay, and who thinks it depends? Quite a lot of you, okay. Well, in law, it depends. You know, it is so much, that's why lawyers always keep saying it depends, because it does depend on the interpretation and the context and the probabilities and which country is involved. You cannot just treat a situation in isolation. You have to actually look at everything, and that's why it depends. And that's one reason why lawyers and technologists, I've noticed, have quite different mindsets. Technologists tend to think in binary, in ones and zeros, in black and white, and lawyers tend to think in shades of grey. And that, you know, there is a good reason for that. So, the answer is it depends. Are you an employee or a contractor? In most countries, probably virtually all, if you're an employee, then everything that the code you create in the course of your employment belongs to your employer in terms of copyright. And even if it's in your spare time, even if it's on your own equipment, at least in this country, it could belong to your employer unless the contract says otherwise. If you're a contractor, actually, you own the code. Even if somebody paid you lots of money to write the code for them, you own it, unless the contract says that they own it and assigns the copyright to them. So it does depend, and in different countries it's different. As I say, in some countries, whose resources you use to write the code can make a difference. So it really does depend. There was a case where a games developer had his own ideas before he joined a company as an employee. He pitched his ideas, that got developed to some extent. He tried to say that it was his copyright in the game, not his employer. And the contract said, there was an own time exception. If you did inventions in your own time, then you own it. But it didn't say anything about copyright. Inventions are about patents. And therefore, actually, because it carved out patents but not copyright, he didn't own it. So the contract makes a big difference. And the timing is really important. Obviously, if you're going to start a new job, check the contract before you sign and go into the job. Otherwise, it might be too late, and you might be stuck with it. And similarly, if you're a company that's hiring a contractor, make sure you've got the contract right before you actually hire them and start the job. And the situation can be complicated with collaborations and joint ownership as well, who owns what if you're actually working together. No time to talk about that now, but this just gives you a flavor that it can be quite complicated and depends on all sorts of things, including things you might not expect necessarily. So, the other side of the coin, what are the risks if you are creating software? And of course, one of the major elements is if you're using other people's code and it's copyright to them, what happens? One major warning is just because code is publicly available doesn't mean it's not copyright. It's not the same thing. And of course, you might be using open source code, but there are complications there as well if you're combining open source code with your own code. And cloud is an interesting example where some companies took open source code and they said, and they modified it, and then they offered it as a service in the cloud, and they said, well, we're not we're not distributing it, so therefore we don't actually have to contribute our modifications back to the community. And the FRO license was trying to get around that, but it doesn't quite work, but you know, that's the attempt, and it shows some of the issues that can arise. Even APIs can be copyright. There was a case here in the EU a few years ago, which wasn't on APIs, but is taken by most people to mean that actually you cannot copyright APIs. But in the US, it's a different matter. I'm sure some of you have heard of the famous case of Google and Oracle, which was about Google's use of Java APIs in Android. And Oracle won in the sense that the court, the appeals court, said, yes, you can copyright APIs. The lower court, the judge before them, had actually said, you can't. And that guy had actually got some programming experience, and he said, you can't copyright APIs. But unfortunately, it went up to the appeals court. The appeals court said, yes, you can copyright APIs. The Supreme Court refused to hear the case, so we're kind of stuck in the US with, yes, you can copyright APIs. Therefore, what Google did was say, well, okay, even if it's copyright, it's fair use. And I mentioned the concept of fair use earlier in the US, and it's quite a broad concept. And in May, a jury in the US said, yes, it's fair use. Oracle has said they're going to appeal, so this is going to run and run. But you know, that's another example. So there are many possible ways that you could infringe. For example, with copyright, lots of things, copying, modifying, communicating to the public, etc. And recently, in the European courts, there was a case about if you link to copyright infringing content, is that a communication to the public which infringes copyright? And court said it depends on a couple of things, which I won't go into. So I've talked a lot about copyright, but there are other IP rights and legal rights that could be relevant, like trademark, database right, etc., and data protection rights. And of course, you have to think about all this, not just in relation to your code, but other elements you incorporate into your software, like graphics and music. So the next bit, exploitation. Getting money out of the software that you've created. And of course, there are lots of issues to do with marketing, advertising, consumer protection, etc. I'm not going to go into that because they're not unique necessarily to software. So one question is, I'm interested to know, when in terms of your own software, your organization's own software that you're selling, who's supplying it for sort of on-prem installation? Okay, okay, not many. Who's offering your company's software through cloud, through SaaS? So quite a few, okay. And who's thinking of doing that if you're not already? No. Okay, so mixture. And I suspect the rest of you, you're probably just using your software, your own software in-house, is that right? No? Okay, so obviously when you're exploiting software, you're giving permission to other people to use your software on payment of a fee or similar. An important point is that your rights and liabilities, and I'm not just talking about intellectual property, but just generally your legal rights and liabilities will vary with how you're giving them permission to use the software. For example, online terms and conditions, they may or may not be enforceable depending on the situation. Your delivery model is going to be important. You've said most of you aren't actually offering software for, on-prem installation, downloading, etc. But I guess a lot of you will be using web apps or cloud. Some of you might be using app stores. The delivery model does make a difference legally. There are obviously risks involved when you're exploiting software, liability for bugs, security issues, etc. And often you'll have contractual exclusions of liability, but as I've mentioned earlier, in some situations, the validity could be called into question. Cloud, a lot of you have said that you're offering your software through SaaS. Obviously, you've got issues with contracts with your own customers, but also because I suspect a lot of you aren't actually self-hosting. You're going to be using AWS or Azure or Google Cloud Platform or IBM Bluemix, etc. You've got your contracts with them. And there is an issue of liability risk if you have mismatching contracts, which is often the way. There are also data protection law risks as a processor that's coming up under the GDPR, but I'll talk a bit about that later. Now, using software, I'm not going to talk a huge amount about, because I was asked to talk mainly about your position as developers rather than as software users, but I just wanted to mention a little bit about that. So again, who is using software, running software in the cloud for internal use by your company? Is there anybody doing that? Or just, yeah, a few, okay. So you're probably going to be using IaaS or PaaS, either to provide services, to provide services internally, I guess, rather than to external customers. Who's planning to? Who hasn't already? No one. Oh, okay. Well, if you're using your own software in the cloud, whether you've created it or you've taken open source software and you're installing it in the cloud, obviously your contract with the IaaS or PaaS provider is going to be important. And normally, as you know, it's on the provider's standard terms, and the scope for negotiation is pretty limited unless you're government body or your financial services, and then you can probably negotiate a bit. There are legal risks when you're using software in the cloud, actually whether it's your own software or somebody else's, whether it's IaaS, PaaS or SaaS. There's the liability position, as I've mentioned. For example, often the ultimate cloud provider will disclaim liability for data integrity. If you're using a cloud service for content, storing content, generating content, etc., then there could be risks there. And I would emphasize, but this is absolutely right, you should involve your in-house or external lawyers early. There have been so many cases where, a project's been going on, the lawyer gets thrown a document and said, and told, oh, wait, it's going live next week, so can you have a quick look? And that's too late for them to do anything about it if there's legal risk in those contracts, which is excessive. It's too late for them to do anything about it if you're going to be going live the next day or the next week. So in the long run, it's actually cheaper to involve lawyers earlier rather than later. And of course, there are lots of related practical issues which you can address through measures like backups, failovers, encryption, etc., if your contract isn't good enough. Or even if your contract's pretty good, it's still much better to have a backup than to have a claim for damages for lost data, which you can never recover. Location is really important because laws are pre-digital, pre-internet, but even pre-digital. However, of course, with the internet and with cloud, there's location independence. The person who's using the service or the end users, they don't care about location except perhaps for latency reasons. But in the law, location makes a huge difference. So, for example, if you are writing a deathless novel and you're storing it in the cloud, or indeed you're hosting it on a server somewhere, it's actually the location of the server which is probably going to be important because that's recording the work that you've created. So that could make a huge difference, whether it's your location or the server in a different country as to which country's laws apply. Another example, in the EU, there's something called a database right when you collect data, not when you create it, but you compile data for a database. If you actually do this and you store your database in the US, which doesn't recognize the database right, and not in the EU, maybe you won't have a database right at all, So that there are lots of factors, and that book does talk a lot about the intellectual property issues with the cloud. In case you're wondering about the picture on the left of a very typical internet user, that's actually meant to represent a Swedish church lady who was prosecuted for uploading onto a website personal data of her colleagues for reading by church members, but she was prosecuted for that in a data protection case. So I said I wanted to talk a bit about data protection because it's one of my main areas, and I think it's going to be a lot more important. Now, currently, we have the Data Protection Directive. That regulates the processing of personal data of data subjects, individuals, by data controllers. I've got lots of quotations around there because a really important point, which I don't think is emphasized enough, is that the same words can mean different things in the ordinary meaning and the technical meaning as opposed to the legal meaning. So processing, to a lot of people, when you use processing data, they think it means computation, as in doing something to the data. But actually, in the legal sense, in the data protection sense, Processing includes storing, just storing data. If you're holding data, you're processing it. If you're just transmitting data, you're processing it. So it's a lot wider than you think. And similarly, the definition of personal data is a lot broader than non-data protection lawyers would think. So there are special meanings in law which only data protection lawyers, for example, will understand in this context. It's not the same as what you would normally think of in the technical sense. Now, the Data Protection Directive has some exemptions, so you don't have to comply with data protection laws if you're processing for personal purposes only, like your email address book. Of course, there's big exception for national security. And the Data Protection Directive is implemented nationally by legislation from each country. For example, here in the UK, we have the Data Protection Act. The liabilities and obligations are on the controller, the person who controls the purposes and means of processing personal data. And the controller has to comply with certain rules when it processes personal data, like fair processing, like security measures. And a controller can use a processor to help it process personal data, but there are more rules that apply there. And the relevance of cloud here is that if you are using a cloud provider to process, to store, or otherwise work on your data, then the cloud provider is considered your processor, whether it's SaaS, IaaS, etc. You have to comply with rules when you use a cloud provider, not just on due diligence, but also what the contract is to contain regarding security and location, as I've already mentioned, is very important. A lot of data protection regulators require data to be kept within the borders of the European Economic Area. And just a brief mention that the Data Protection Directive is not the same as the infamous cookie law or laws about human rights, misuse of private information, etc. They overlap, but often to the same situation, you can actually apply different laws and see which one applies and how. And even the phrase data protection has a different meaning in the legal sense as opposed to the IT sense. I'm sure you've heard of the General Data Protection Regulation, and this replaces the current directive from May 2018. Potentially, there are huge fines, including for security breaches, and their fines are not notifying breaches when you should have. And it's really important and relevant, even though we have, in the UK, Brexit. Because, A, if you're doing business, if you're in the UK, but you're doing business with anybody in the EU, then it's still going to be relevant. And secondly, if the UK generally wants to be considered a country that is fit to do business with the EU, then adequate laws, then it has to have something similar to the GDPR in order to enable that. A major point is that processors are directly liable under the GDPR, including cloud providers. Is anybody here from a cloud provider? No? Okay, but yeah, they are going to be directly liable. And I suppose actually if you are providing your software as a service via SaaS, then you are a cloud provider, okay? You're considered a cloud provider for the processor for the purposes of data protection law. And what's interesting, and perhaps not so positive for you, is that if you were offering your software for on-prem installation, download, whatever, then you wouldn't have these new processor liabilities. But if you are offering your software as SaaS, as a service, then you are considered a processor, and you are going to have these obligations and liabilities under the GDPR. So the delivery model actually makes a difference as to what your legal position is going to be. Now, I don't have time to talk about the GDPR in detail, so here's a quick workout. That's a barbell that the dog is holding in case anybody can't see. ABS, accountability. Not only complying, but proving that you're compliant, and audit rights. Big fines, I'm sure you know about, which make this a boardroom issue. And there's two tiers. There's the lower tier, which is 10 million euros or 2% of annual turnover if higher, or 20 million euros and 4% of annual turnover if higher. And this is the group's annual turnover. This is not just the offending organization. So if your company is part of a group, they're looking at the whole group's turnover. This is competition law proportion type fines. S for security. Security obligations not just on data controllers, but on processors, including cloud providers, including SaaS service providers. Just to give you a picture, if you see those tiny slivers on the left, those are the single biggest fines that the UK Information Commissioner, the UK regulator, has issued over the last 5 years. And even TalkTalk a couple of weeks ago, that would have probably been about the size of, I think 2013 or 2014 was the biggest so far. And if you compare that to the 2% and the 4% rate, the yellow and the red of a large UK financial services company, you can see that it really dwarfed in comparison. And even if you take the 10 million or 20 million euro amount, which are the two on the extreme right, then you can see that the fines to date are tiny compared to what's possible. And those were pre-Brexit rates, so they would be even higher now. Next, biceps. Breach notification obligations for the first time if it's personal data. International transfers, storing or processing, otherwise processing personal data on servers which are located outside the EEA, more and tighter restrictions, generally. Class actions, quasi-class actions are going to be possible. So you have to worry about not just fines, but also quasi-class actions and compensation. Enforcement powers are going to be bigger. Processes I've already mentioned have direct obligations and liabilities and requirements about the contract. Security, I've already mentioned, but security by design is going to be important. And if you've got good security requirements and you can show, you've got good security measures, industry standard, etc., that can be a factor to reduce your fine if there is a breach. So it's really important there. PECs. Procedures, organizational procedures are going to be important, not just technical or legal measures. Encryption, tokenization, etc. are going to be a lot more important, and codes and certifications approved for GDPR purposes, not just industry standard, but approved for GDPR purposes, are going to be a lot more important to show compliance and to reduce fines and so on. And S will start preparing now because it's less than 2 years. So from a developer's viewpoint, if your software is actually dealing with personal data, I've picked out a few. Accountability, evidence. Privacy by design. Those obligations apply to controllers. Security obligations, I've mentioned, they apply to controllers and processors. So all this means that secure coding is going to be a lot more important. For example, taking action against SQL injection, etc. Secure architecture, encryption everywhere you can. That's going to be a lot more important. Data minimization and deletion retention, not collecting personal data unless you absolutely have to, deleting it as soon as you can, because that's going to increase your liability if you haven't minimized your data and there's a breach, for example. And there have been a couple of fines where there were hacks, and one of the fines, and one of the reasons for the fines was, oh, you've kept all this data, you didn't actually need it. This was from customers from years ago, you've still got it, and that's been breached. So, that actually is an aggravating factor towards your fine. A final thing there, access controls, logs, and audit trails. Because of this accountability and evidence emphasis, it's actually going to be much more important to have logging and so on. So if you're producing software, and that's meant to handle personal data, your customers will be demanding more logging and audit trails and that sort of thing. So you'll need to try and build those in. And of course, an interesting twist is that even logs could contain personal data themselves. So delivery model offering cloud is going to be a lot harder. If you're offering your software as a service, as opposed to just for download and on-prem installation, there's going to be a big difference. These required contract terms will be much more detailed, and difficulty is they have to be flowed down. So you're providing a SaaS service, you're using, say, AWS. AWS may be using a third-party data center and so on. Your obligations in your contract with your end users have to actually be flowed down. So you're going to have to go to Amazon and Microsoft and Google, etc., and say, I want you to actually accept these tougher obligations. They might have to flow down to the data center operator if it's a third-party data center. And I'm not sure how it's going to work out in cloud. And this is actually going to be not just cloud, but lots of modern supply chains. And I've already mentioned the tighter requirements on data location. And remember, it's not just physical location of data that matters. It's not just data center location. It's also remote access. So if you've got staff, if you've got contractors in India or wherever who are actually providing support, then their remote access to data, that's a transfer which has to comply with the rules in the current current data protection directive as well as the regulation. Ray of light, as I've said, is there will be these GDPR approved codes and certifications, and if a company's got one of those, you could actually transfer to them without any issues. There are different considerations, again, for mobile apps and the App Store model. So the delivery model is going to make a big difference. And I'm worried about the impact that GDPR is going to have on the cloud. Again, only seeing this in the shower for Roberta Flack or Fuji fans. So really, you've got to plan ahead. I mean, 2 years, less than 2 years, isn't long at all. Privacy by design and privacy engineering is going to be a lot more important. And also, privacy impact assessments or data protection impact assessments. So as part of before you actually start a new project, a new service, a new product, your risk assessment has got to include data protection as well as other issues. And cloud is going to be a lot more difficult, but do consult your tech lawyers early, sooner rather than later. And I would also mention a slight warning. I have seen so many things out there which say GDPR is coming, this is really scary, huge fines. Buy our product, buy our service, and you'll be okay. Be careful about that, because as I've already mentioned, data protection law is quite specialist, and the terms can mean different things. You might read the words, but that doesn't mean you actually understand the legal implications, because they have different meanings in law and real life and IT and so on. So just be a bit careful about that. I've seen actually quite a lot of mistakes out there, even in the media. They say, oh, the GDPR is going to do this, the GDPR is going to do that, and some of them are quite wrong. So just be a bit careful about that. There are some sources for free IT law advice, so there's no excuse not to get it if you need it. Q Legal for startups. Boot Law has free meetups, again, particularly for startups, including IPOs, etc. Own It has IP advice, not necessarily IT, maybe more music and art, but there is some on IT. But full disclosure, I'm associated with the university behind Q Legal, although I'm actually got nothing to do with Q Legal. And I'm associated with the law firm behind Boot Law, but they do happen to be, I think, the best in that area in London at least. And of course, they can only advise on the position here. Different countries have different requirements, so you've got to be careful to make sure you talk to lawyers in the relevant countries. And for legal news affecting technology, Outlaw, I personally think is the best. Again, the law firm that I am associated with is behind Outlaw, but I was reading Outlaw even before I joined them, and even before I became a technology lawyer. SCL.org is actually a great site for, again, technology law news and more analysis. Again, I'm disclosure, I'm on the editorial board for that, but it really is a great site, and a lot of the content there is now free. And of course, there are lots of blogs around that provide free information about technology law. There are lots of data protection resources. Obviously, best practice resources for security are going to be good for security. And regulators actually come out with opinions and guidance. For example, the Article 29 Working Party, which is the EU regulators collectively. In the UK, we have the Information Commissioner, and they've got guidance on things like mobile apps and on big data and so on. And that's the link to a note on the GDPR at Pinson Masons. So please rate the session, and thank you very much for your attention. I don't want to keep you from your lunch, so if you've got any questions, catch me at lunch or tomorrow or whatever. Thank you very much.